So how did the emergence of the child abuse panic of the 1980s affect Canadian laws? It became an incremental process to make it easier to convict those accused and to strip them of any defense. The first major step was to repeal the requirement for corroboration in cases of sexual offenses. Up until 1983, corroboration was specifically required where there was only evidence of the complainant unaccompanied by material evidence that could implicate the accused in sexual offense cases. The unsworn evidence of a child provision also fell under the same limit, but was reversed a little later in 1987. After this reversal, the corroboration not required provision has since been automatically applied to every newly created offense of a sexual nature in relation to adult and child complainants. The second major step was to repeal the federal statute of limitations law. Up until 1987, there was a one-year limit for criminal proceedings of sexual offenses after the time when the offense is alleged to have been committed. This one-year limit was repealed in 1985 and came into effect in 1987. Thus, no statute of limitations exists still to this day. Into the 1990s, the hysteria was still in full swing. The new legal provisions have opened the door to encouraging a bounty of false accusations that would ultimately line the pockets of defense lawyers and fill the coffers for victims' advocates campaigning for funding dollars. But this decade also saw social change happening in the form of new police enforcement techniques, prompted by handbooks of how to handle sexual abuse cases, written by feminist groups and social workers advocating for women and children. This book, Canada's Law on Child Sexual Abuse, a handbook, was written by Mary Wells. The description of this book is as follows. The changes to the Criminal Code and the Canada Evidence Act on January 1, 1988 created new child sexual abuse offenses and expanded the opportunities for courts to receive children's testimony in cases of child sexual abuse. This has major implications for professionals working with sexually abused children, particularly social workers who will find themselves increasingly participating in investigative activities and may be required to give evidence at criminal trials. This handbook outlines the criminal justice process and its principles, explains the law on child sexual abuse, discusses the need for the adaptation of investigative methods when a child sexual abuse case becomes a criminal justice matter, explains changes in the rules of evidence relating to child witnesses, and suggests roles child protection workers may assume under the new law. However, as you can see, this book was originally titled Guidelines for Investigative Interviewing of Child Victims of Sexual Abuse. She originally wrote this in 1984, and it was released via the National Clearinghouse on Family Violence, before it was picked up by the Department of Justice Canada. And then ultimately, at least 600,000 copies were distributed in English and French across Canada. A little bit about Mary Wells. She has a bachelor's degree in sociology and social work. She's been working in the nonprofit sector for most of her career. Her online LinkedIn profile doesn't go back any further than 2004 of her working career. Inside her manual, you will find advice to interviewers such as this. The interview with the child may consist of straightforward questioning, but may also be supplemented by the use of various play objects such as puppets, dolls, both regular and sexually explicit, drawing materials, dollhouses, and toy telephones. The child, not the interviewer, should approach and select the dolls. If the child demonstrates sexually explicit behavior with the dolls, this may cast light on the information that the child has been given verbally. Sometimes the interviewer may ask the child to explain verbally what is being demonstrated and ask very specifically if it is intended to represent a real situation. Research on the use of anatomically explicit dolls and their effectiveness as a diagnostic tool is currently underway, as of the time this book was written. And then it continues on to say, where possible, children should be interviewed alone. Here is a sample video clip of one American police force training video on recognizing symptoms of satanic ritual abuse and sexual abuse in preschool-age children.
Symptoms characterizing satanic ritual abuse and sexual abuse in preschool-age children. Low self-esteem, feeling of being bad, child feels deserving of punishment. Child is fearful, clingy, regresses to baby behavior. Separation anxiety. The child is angry and aggressive. The child acts wild, uncontrolled, hyperactive. The child is accident-prone or deliberately hurts himself. The child is negativistic, resistant to authority. The child mistrusts adults. The child is over-compliant with authority, over-pleasing with adults. The child has rapid mood changes. The child is withdrawn, does not play, or plays in a lethargic or unfocused way. The child exhibits a short attention span. The child does not learn. The child's speech is regressed and babyish. He has delayed speech or speech disorder. The child's speech production decreases significantly. There are somatic complaints, stomach aches, nausea and vomiting, nightmares, and sleep disorders. The child is fearful of being touched, fears having genital area washed. The child touches his genitals or masturbates excessively. The child touches or tries to insert fingers into his rectum. The child pulls down his pants, pulls up her dress, or takes off clothes inappropriately. The child touches others sexually or asks for sex. The child is sexually provocative or seductive. He or she complains of vaginal, anal pain, burning when washed or when urinating or defecating. Semen or bloodstains are found on the child's underwear. Detailed and age-inappropriate understanding of sexual behavior. Hints about sexual activity. The child complains that an adult or older child is bothering them. A reference to blood or white stuff in genital area. A statement that someone had removed the child's clothing. A statement that an older child or adult exposed themselves to the child. A child's statement that he or she touched an older child's or adult's bottom, vagina, rectum, mouth, etc. A statement that an older child or adult touched or penetrated the child's bottom, vagina, rectum, mouth, etc. A statement that the child witnessed sex acts.
As you can see, there are many symptoms described here that are typical behaviors of children. Today, many of these symptoms are treated with Ritalin or other medications. It is alarming to think that parents would fall under suspicion of such despicable acts after a school teacher or counselor or daycare makes a phone call to an authority asking for an investigation into the child's home life. Once that happens, various authorities begin asking repeated questions until they get the answers they want. As we saw from the 2020 video clip I played you in part 1 of this series, you can see how suggestible and persuasive kids can be. The 90s decade also saw adults, mostly women but also men, were claiming to have been sexually abused as children by members of their family or someone else they knew. In Canada, we had recognized so many miscarriages of justice in this area that the Canadian Psychiatry Association and the Canadian Psychology Association had strongly warned the legal system to exercise extreme caution when considering convictions based on such memories where there is no corroborating evidence. And in 1998, the Criminal Lawyers Association had asked the Justice Minister to open an inquiry on the men convicted of such charges. Alan Gold, then president of the association, urged that all prisoners convicted based on the sole uncorroborated memories of accusers be released. The letter included signatures of an extensive list of professionals from all across Canada. The then Justice Minister, en&ct, was a feminist who swiftly and flatly denied the request. Her view was that it was premature to take any action beyond the usual route of reviewing wrongful conviction cases individually after all appeals are exhausted. With that response, she ultimately reveals that the justice system is more interested in keeping lawyers, crowns, sex crime police officers, and improperly trained, unethical therapists employed, rather than vindicating financially and emotionally broken innocent men. Other feminist psychologists and lawyers supported her decision, citing trauma theory as accepted science, completely ignoring what several other countries had rightfully addressed as unproven or even junk science. The year before the Criminal Lawyers Association sent the letter to en&ct, in 1997, with much debate and controversy, lawmakers added a third-party records provision to further diminish the accused's right to a full answer and defense. In particular, therapy, counselor, or psychiatric records come with a long list of disqualifying criteria for them to be admitted as evidence. Insufficient grounds to have these records admitted include that the record may relate to the reliability of the testimony of the complainant or witness merely because the complainant or witness has received or is receiving psychiatric treatment, therapy, or counseling. The defense must specifically state, for example, that they suspect the complainant's memory may have been shaped by the therapist, counselor, or psychiatrist. However, even if successful in getting these records admitted, it is possible that the therapy notes submitted for the purpose of the court might be unhelpful bullet point notes that don't reveal any useful information, thus continuing to make it difficult for the defense, where the suspect is indeed innocent as charged. On the other hand, such notes could potentially provide a basis for the defense lawyer to argue for a more convincing reasonable doubt resulting in a rightful acquittal. For example, if the notes contained information pointing to a diagnosis of multiple personality disorder or dissociative identity disorder, it can open the door to scrutinizing unproven trauma theory that revolves around suppressed memories of childhood abuse being the cause of such disorders. But this method will only work if it's done by an educated lawyer who understands the debunked science, as well as a judge who also understands the debunked science. If you have a feminist judge and you have a defense lawyer defending you that has no knowledge in this area, they haven't been trained properly in this area, then none of that's going to help you. The Supreme Court of Canada has yet to deal with such a discussion. Therefore, there are little safeguards in place to prevent an innocent person from wrongful conviction as a result of therapy-induced false memories of historical abuse. In fact, the third-party records provision, as it is currently written, strongly discourages such defenses to be raised in a trial. When a person, usually a man, is convicted in this kind of she said, he said case, these are convictions that stay in the books to support future convictions by way of setting precedents in case law, tipping judgments dangerously toward a balance of probability. Feminist-influenced judges tend to heavily cite historical case law containing unproven, untested, and even debunked feminist theory and trauma theory. to justify the framework of their decision for a questionable guilty verdict, rather than come to a fair judgment based on the merits of the case, in the absence of any material evidence proving guilt beyond a reasonable doubt. Fast forward to the 2000s, and adults were still claiming to have new, repressed memories of childhood sexual abuse. Although some might reword it as always having the memories within, but having blocked them due to the trauma of the event. It has become routine for feminist and ideological therapists to recommend the book The Courage to Heal, a guide for women survivors of childhood sexual abuse, since its release in 1988, to help their clients come to terms and believe the newly constructed memories of sexual abuse to be the complete truth and no fault of their own. This book also encourages those who are truly mentally ill to find a reason that might make sense to them to blame their mental illness on something somebody else did to them in their past instead of addressing the true nature of their mental illness of the present day and treating it properly. In part 3 of this series, I will further analyze today's prevalence of historical sexual abuse, criminal court cases, the use of trauma theory, feminist theory, and the harm it does to those with true mental illness, as well as those who are accused of being the cause of such mental illnesses. This next clip of an Australian therapist who was recently interviewed by ABC Australia is a preview of the dangers of an unregulated therapy industry that I will be discussing in the next part of my series.
Can you treat people who have recognised, diagnosed mental illness?
My approach is very different. Okay, so my approach is very different in the sense that what people have been conditioned into calling illness to me is a completely natural response to an event in your life. It's not wrong, it's not inappropriate, it's not even an illness, okay? There's like a dual personality. You know, where one part is a traumatised person and the other part is a person the personality that the person uses in day-to-day life.